Welcome to this explainer. Today, we're diving into something absolutely crucial to the very foundation of our U.S. government, and that's the balance of power. Specifically, we're looking at a growing, really profound debate over the limits of the judicial branch. It's a topic that actually touches all of our lives because, ultimately, it asks the question, who is really writing the rules that govern the nation?
So here's the big question we need to tackle. When exactly does a judge, someone tasked with interpreting the law, cross that invisible line into actually creating policy? Our source materials dig deep into instances where a single judge can literally pause or alter federal policy for the entire nation. And as you can imagine, that raises some serious questions about our constitutional guardrails.
Here is our roadmap for today. 1. Rule by injunction. 2. The procedural tug-of-war. 3. The rhetorical divide. 4. 3 failures of restraint. And 5. The institutional cost. Section 1. Rule by injunction. The district court landscape. Let's start with a term that pops up constantly in our sources, the nationwide injunction. This is widely considered an extraordinary legal remedy. It basically means that a single district judge, just one person, sitting in a single courtroom, can issue an order that immediately blocks a federal executive policy for the entire country. We're talking about an impact on 330 million Americans. That is an immense amount of power for one individual to wield. And this brings us to a really fascinating systemic pattern identified in the texts. The sources highlight how several federal judges appointed during the Obama administration, folks like Judges Talwani, Chhabria, and Watson, have issued early, aggressive, nationwide injunctions against federal policies. The material points out a recognizable pattern here, where these judges frequently treat a preliminary harm as enough of a reason to intervene early, using these nationwide injunctions to halt executive actions across multiple different presidential administrations. To ground this in reality, let's zoom in on Judge Indira Talwani out in Massachusetts as our primary case study. She blocked mail voting restrictions, preserved parole protections for over 500,000 migrants, and temporarily halted Medicaid funding cuts to Planned Parenthood. These rulings are massive. They address election rules, immigration policy, and healthcare funding, all on a national scale. It really shows you the real-world stakes of these high-profile administrative law cases. Section 2. The procedural tug-of-war. Higher courts push back. So how does the Supreme Court respond to all of this? Well, their pushback is heavily rooted in a procedural concept known as the ripeness doctrine, rather than just purely ideological disagreements. Basically, the ripeness doctrine says that courts have to review final concrete rules. They aren't supposed to review proposed rules or just anticipated harms. As our sources frame it, the Supreme Court's message to these district judges is largely procedural. They're essentially saying, hey, you can't block a rule before it actually exists. Let's see how this actually played out in the summer of 2026 regarding mail voting. In June, Judge Talwani blocks an executive order. But jump ahead to August 24th, the Supreme Court stays her injunction, stating it was simply premature because the Postal Service hadn't even issued a final rule yet. 2 days later, Judge Talwani lifts her remaining injunction, acknowledging the higher court's reasoning. It's a literal procedural tug-of-war. The Supreme Court didn't even say her constitutional analysis was wrong. They just told her she acted too early. Section 3. The rhetorical divide. Justice Jackson versus the majority. What is really striking here is the stark contrast in the rhetoric being used. Our sources impartially highlight this massive divide. When the Supreme Court issues emergency orders staying these nationwide injunctions, Justice Ketanji Brown Jackson has written some very vivid dissents, calling the precedents a Kafkaesque nightmare or warning that the court needlessly injects chaos. On the other side, the conservative majority frames the issue strictly around procedural timing. They use words like premature or say it requires final agency action. So it's this intense clash between framing the issue as an existential threat on one hand versus a narrow matter of timing on the other. And the source material suggests this divide isn't just along the usual conservative and liberal lines. In that mail ballot case, Justices Sotomayor and Kagan authored a much more measured dissent. But Justice Jackson actually refused to join them. Instead, she wrote her own separate 23-page dissent. The sources point out that this split signals that even her liberal colleagues might view her tone as a bit too confrontational, which kind of isolated her within her own bloc. Section 4. 3 failures of restraint, timing, scope, and role. The authors of our sources analyze this whole phenomenon, and they break down this overstepping of the judicial role into 3 distinct failures of restraint. We have the failure of timing, the failure of scope, and the failure of role.
Let's walk through each one to really grasp the gravity of this constitutional debate.
First up is the failure of timing. The core argument here is that federal courts exist for one main reason: to resolve actual, concrete disputes between parties. They are absolutely not meant to issue advisory opinions about policies that haven't even taken effect yet. When a judge intervenes before an agency finalizes a rule or before a voter is actually harmed, they're treating anticipated illegality as a present injury. According to the texts, that is the complete opposite of judicial restraint. Next is the failure of scope. Usually, a preliminary injunction is supposed to be tailored, but a nationwide injunction? That allows plaintiffs to basically go forum shopping. They can handpick a single judge in a place like Honolulu or Boston who can then effectively set policy for the entire nation. As this quote from the George Mason Law Review points out, this practice gets criticized across the ideological spectrum because, frankly, it looks a lot more like sweeping legislation than traditional localized adjudication. And that leads us to the biggest one, the failure of role. The sources argue that the actions of these district judges and Justice Jackson's defenses of them don't just bend the rules. They represent a profound shift in how the very role of the judiciary is fundamentally understood. They're advocating for a new theory where courts intervene earlier, way more aggressively, and much more broadly to check executive power. Essentially, they're treating that ripeness doctrine as a loophole rather than a hard constitutional boundary. But this modern theory clashes pretty hard with what the framers actually intended. Alexander Hamilton famously wrote in Federalist No. 78 that the judiciary has neither force nor will, but merely judgment. The Constitution purposely designed the judiciary to be the least dangerous branch, completely separate from legislative and executive powers to prevent tyranny. Relying on judgment, not will, means you have to wait for a concrete dispute.
Section 5, the institutional cost, instability, and legitimacy. This is really the crux of the whole explainer. The texts argue that judges who consistently act as national policymakers on a compressed timeline violate constitutional limitations on the judicial role. And what happens when they do that? We end up with rushed Supreme Court reviews without proper briefings, totally unstable shifting nationwide policies, and judicial micromanagement of executive agencies. Ultimately, this pattern ends up undermining both democratic accountability and the legitimacy of the judicial branch itself. Now, to be completely fair and impartial here, our sources do present a very serious counterargument coming from the Case Western Reserve Law Review. Their argument goes something like this. We live in an era of intense congressional gridlock. When the political branches are hopelessly deadlocked, the judiciary might literally be the only effective check left. From this viewpoint, nationwide injunctions serve as a vital, immediate defense against executive overreach and fundamental rights violations. However, the sources offer a really strong rebuttal to that perspective. They emphasize that if we start justifying judicial legislation just because Congress is gridlocked, then we effectively throw out all constitutional limits on judicial power. The remedy for a broken legislature has to be fixing the legislature. It cannot be relying on an imperial judiciary that issues nationwide injunctions before rules are even finalized. So what's the big takeaway from all of this? The texts conclude that judicial restraint isn't about weakness. It's an absolutely essential structural guardrail of our democracy. It protects democratic accountability, making sure that unelected judges don't make policy for 330 million people. And it protects judicial legitimacy. Proper judicial review has to operate at the right time, in the proper posture, and with the proper scope. I want to leave you with a provocative question to chew on. When a single judge issues a nationwide block on a policy before it even takes effect, is rule by injunction actually checking executive power, or is it simply replacing it with judicial power? It's a really profound question about the true balance of power in our government. Thank you so much for exploring this fascinating constitutional debate with me.